1960 y 1970, Lord Leicester estuvo directamente involucrado en la redacción de legislación sobre relaciones raciales en Gran Bretaña. Durante ese tiempo se desempeñó como presidente de la Subcomisión de Asuntos Jurídicos de la Campaña contra la Discriminación Racial y fue miembro de varias organizaciones que trabajan por la igualdad racial, tales como la Sociedad de Abogados Laboralistas, la Fabian Society, el Consejo del Instituto de Relaciones Raciales, entre otros. Fue presidente de la Fundación Runnymede entre 1991 y 1993. Es profesor adjunto de la Facultad de Derecho de la Universidad de Cork, en Irlanda. El 29 de junio del año 2007, Lord Leicester fue nombrado por el primer ministro Gordon Brown como asesor especial sobre la reforma constitucional para el secretario de Estado de Justicia. Además, es miembro de la Comisión Mixta de Derechos Humanos. Muchas gracias, Lord Leicester, por estar con nosotros. Y voy a presentar al otro panelista de este panel, que es Christopher Barnes, que acaba de hablar sobre Barbados, pero él es subdirector ejecutivo de la compañía editora de Gleanner, ha sido miembro del directorio de Sangster's Bookstores Limited, renunció a ese lugar en diciembre de 2009, y actualmente de Independent Radio Company Limited, Caribbean News Agency, Caribbean Media Corporation, Jamaica, National Overseas, USA, Gleanner Online Limited, The Gleanner Company, Canadá, Ocho Ríos Beach Limited y PALS, Jamaica. Forma parte de la Comisión de Política Económica del Sector Privado de Jamaica y del Comité Ejecutivo de la Asociación de Medios de Jamaica. Antes de incorporarse a Gleanner, trabajó por 10 años con Alcan Inc. en varios cargos internacionales, incluyendo el último como director de iniciativas estratégicas. Es vicepresidente de la Comisión de Premios de la CIM. Vamos a manejarnos con un sistema de 10 o 15 minutos para cada uno. Luego podemos dar preguntas que hayan entre el público, ustedes las responden. Y así que le doy la palabra a Lord Leicester para que comience su exposición.
Thank you very much indeed, Mr. Panelistas, your inspiring opening statement, and thank you to the Association for inviting us as guests to this important conference. Can I be heard? When I heard your over-generous introduction, Mr. Paulillo, it reminded me of what happened when Henry Kissinger received the Nobel Peace Prize. After he had done so, an American lady came up to him and said, Dr. Kissinger, I wish to thank you on behalf of all humankind, to which he replied, you're welcome. It was too generous, but it was incomplete in one important respect. I have spent all my adult professional life defending newspapers and supporting my version of the First Amendment to the United States Constitution. I'm sorry that Mr. Feely is not in his place. Were he here, I would suggest to him that he should read my article entitled Two Cheers for the First Amendment, not 3 but 2, which is published in the Harvard Law and Policy Review currently, where I try to explain that all is not perfect in the land of the free and the home of the brave. You have asked me to talk about the situation in the United Kingdom. Now, of course, the oppression of the journalists and the press throughout Latin America, Africa, Asia, and a good deal of Europe is something so shocking and so important that it's strange to focus upon the situation in the United Kingdom. where, although things are far from perfect, they are nothing like as bad as in many other countries. But there is some justification for looking at the situation in the United Kingdom, because it could serve as a very bad precedent for what happens in Latin America and elsewhere. Really what I want to say comes under the title, A Plague on Both Your Houses, because the British press, as well as politicians, have been responsible for the present mess that we are in. I have to say something about the responsibility of the press, because all of you represent the press here, and it's worth remembering that not everything that newspapers do is wise. When we introduced our Human Rights Act in 1998, which is our substitute for a written constitutional guarantee of fundamental rights, I was contacted by the lobbyist of a major British media organisation. I will not name them, but you may be able to guess who they are, who said, would I please make sure that newspapers had a complete impunity from anything to do with media intrusion on private life. I said, certainly not. The press, like everybody else, must respect fundamental human rights and freedoms. As a result of that media organisation and most of the conservative right-wing British press have attacked the Human Rights Act and the European Court of Human Rights day after day, week after week, in much the same way that Fox News behaves in the land of the free. It has been disgraceful. It has poisoned the public mind. And as a result of that, the press in Britain are delighted to take freedom of expression as guaranteed by the Human Rights Act and rely upon it, but they are not willing to accept that there may be a right of personal privacy. Now, what happened as a result of this mistake on the part of many of our newspapers is that when the hacked off abuses by the press, hacking into people's telephones, private lives, in the most disgusting and unacceptable way, when that scandal broke, the politicians, who in any case dislike the press for all kinds of bad reasons, the politicians reacted by saying we would set up an inquiry into press abuse. And that was the first mistake that the politicians made. They chose a criminal judge, a fine criminal judge, who knew everything about crime and nothing about press regulation. He produced, this is Sir Brian Leveson, he produced a report which diagnosed the problems of the press and the failure of the press to produce an independent system of press regulation of the kind that was necessary. He quite rightly explained how the Press Complaints Commission, owned and funded by the big media organisations, had failed to provide effective redress to victims of press abuse, had failed to provide effective remedies. And had his report left it there, it would have been fine, because it would then have been for the newspapers to set up a proper system. But instead of that, the judge overreached himself, and he then came up with a number of very bad recommendations as to what should be done with a new system of press regulation. And the worst of his ideas was that in order to persuade the press into a new system of press regulation, so-called self-regulation, they should be liable to exemplary or punitive damages if they failed to join the scheme. That was the reason why I, from the very beginning, passionately opposed the idea that Leveson put forward. However, the politicians in my country, by this time, were extremely angry that their misuse of power in fiddling parliamentary expenses had been exposed by newspapers to the public. They're not very well paid parliamentarians in Britain, and so they've been fiddling their expenses on a spectacular scale. And they were very cross to find the newspapers exposing them. As a result, some of them lost power, some of them went to prison, and they were angry. And as a political class, hostility to newspapers grew stronger. They even tried to get an exemption for Parliament from the Freedom of Information Act in order to manage to hide their fiddling, their misuse of power, and they failed. So the politicians read Leveson, thought that the press had behaved disgracefully, which they had in the hacking off of individuals, and they then decided, the three political parties, including my own, decided, meeting in secret, week after week, to devise a ridiculous system, so complex and so worrying that I could hardly believe it. It was a form of Anglo-Saxon political complexity. As a result of that, the press decided to boycott the government scheme. I'm not going to delay you by trying to explain the government scheme. It would take me at least an hour to begin to do so, even if you were lawyers, which most of you, I suppose, may not be. But in brief, they set up a royal charter, which is a kind of legislation, with a very complicated scheme for recognizing a new form of press regulator with exemplary damages sanctions if newspapers did not choose to sign up. I'm glad to tell you that the way that this united the British press, newspapers are very rarely united in my country, but it united the newspapers in my country remarkably well, and they decided to boycott the new system and instead to set up a system of their own. Now, the politicians were very angry because they were thirsting for blood, and they did not like the idea of the newspapers boycotting the system. And they still threaten, if the newspapers go on boycotting the system, to legislate against them even more. That is their threat. But what has happened is this. Most of the British press, except the Financial Times, the Guardian, and the Independent, decided that they would set up an alternative system. A system which enables the regulator to impose fines of up to £1 million on newspapers that misbehave. But a regulator which is well funded, able to give effective remedies, able to advise the press on appropriate press standards, and able to do all the things that the old failed Press Complaints Commission was unable to do. And I'm glad to tell you that my latest information, received yesterday, is that it now looks as though the Guardian and the Independent and the Financial Times will join the new scheme as well. If that happens, and by the way, they're now advertising for a new independent chairman and an independent board of management, and the person who is doing it is independent himself, with an independent former judge doing it with him, if they choose the right people to run the scheme, even though inevitably the big media organizations will be the funders, and some will say, therefore, the scheme is hopeless. I do not agree. If that happens, all the British press that matters will join the scheme. And if that happens, then I believe that whatever happens in our general election in 2015, the future government will not dare to interfere and set up or rather enforce the charter scheme. So in one sense, what I'm saying to you is that there is a continuing threat, and there is. But on the other hand, I'm also saying to you that I believe that the British press now are setting a good example of putting their own house in order. And many of the journalists, we have quite enough law in Britain restricting free speech, quite enough criminal law, quite enough civil law. And many of the journalists who have committed crimes are being prosecuted or have already been prosecuted and are already serving prison sentences, quite rightly, for their abuses. So I think that the situation, that the United Kingdom picture is important, both in saying do not have ineffective systems of self-regulation, do not allow journalists to behave grossly in what they regard as the public interest, but is in fact the commercial interest of a newspaper or organization to violate personal privacy. Do not allow that. Make sure your own systems work properly and fight like tigers against any attempt to impose state regulation on the press. I hope I've said enough at least to indicate that what I've just said. There's one final point I should have made. I spent 3 years reforming our system of defamation law. We had abolished criminal defamation some time ago. But my Defamation Act, which came into force in January, is far better. I hope Mr. Feely will forgive me. It's far better than the situation in the United States when it comes to libel law, in my opinion. Now, it was that bill that was taken hostage by politicians who tried to impose punitive sanctions before my bill could become law. Luckily, we got the bill through in January. The politicians will not ever give up trying to persecute the press, but my judgment is that they will fail. Thank you for listening to me.
Thank you, Dr. Odysseus, for this brilliant presentation that illustrated all of us what's going on in your country. Please, Chris, go ahead.
Thank you, Chairman. How do you follow such a presentation other than to express grave concern for the region about what Lord Anthony Lester has just said? We certainly hope that the scheme that the newspapers have been forced to come together, to put together, actually comes off, and that there is no government interference, if you will. But I think our position for the region, and I can speak to the Jamaican experience, and if you can put the presentation up. In relation to the Jamaican experience, I have the opportunity to chair the Media Association of Jamaica. Those logos off to the left-hand side of the screen are some of the companies that we represent, that represent the bulk of readership and viewership in Jamaica, as well as the bulk of advertising revenue in Jamaica. Can you go to the next slide? So the MAJ was founded in 1964 as an association of media owners with a mission to strengthen Jamaican society and democracy through the fostering of a vibrant, independent and responsible media. the media houses that we run work together on common industry issues, though we compete in the market fiercely. Some key things that we've worked on over the time of existence, between 2005 and 2011, we have been working on revising a code of ethics for journalists, which was first established in 1965. So we do have rules that govern how our journalists engage and indeed our media houses function. 2007 was a landmark year where an independent committee was set up to propose changes to the country's libel and defamation laws. I'll speak to that a little bit later. In 2013, some 6 years after, the Defamation Act or the revised defamation laws were passed by the House of Parliament. There coexists a working relationship, or we coexist with the Working Journalists Association, which is a press association of Jamaica, and there's generally a collaborative approach to media development and advocating for press freedom. Next slide. In Jamaica, and I guess the argument is the same for the region, media sustainability is challenged by, one, a stagnant economy. This region is not immune to what is happening globally. And as a result of these stagnant economies, there's less money going around and less fuel to support the work that us as media houses do. There's a proliferation of new media and new technology, which the traditional media is trying to grapple with as well and continuing to remain sustainable. There is certainly in Jamaica what we feel is overzealous regulation, and this is particularly in broadcast media, as in print media there is no regulation, where the regulators are seeking to push too hard to move the existing broadcasters into the new era of technology at great cost, which puts great burden on these media houses in the environments under which we operate. In spite of the upgrade to our existing libel laws, we still have very restrictive libel laws. The Act of 1851 and the Defamation Act of 1961, as I said earlier, has just been upgraded by the Act of 2013. We have had landmark cases in Jamaica in relation to libel and defamation, including one with my very own media house, the Gleanner Company, which back in 1990 had a claim awarded against it for some 80 million Jamaican dollars, or nearly 1.2 million pounds at the time. That number was halved, or that amount was halved under appeal to about 35 million Jamaican dollars, or about £500,000 pounds. But when added to legal costs, it took it right back up to the original claim. Now, there are very few media houses across the region that would have been able to sustain a blow like that and remain in operation. That was a significant threat to press freedom. With the developments in the UK in regards to the Leveson Report and the Royal Charter, there has been a renewed call by the government and the Journalists Association in Jamaica for the establishment of a Press Complaints Council. And if you move on, so that's the sort of the industry dynamics that we're in. In terms of the Defamation Act and the upgrade in 2013, what we've had is the abolition of criminal libel, which is a great thing for the region. No journalist can go to jail for the work that they do in terms of libel and defamation. Apology is not an admission of guilt. The damages must bear a rational relationship to the harm suffered. There is no libel tourism, where you can move from country to country and file claims against media houses in those jurisdictions. We now have a wire service defense. More and more news houses in the region depend on wire information, and we select our wire service providers based on their credibility within the markets that they serve. And so now we have a defense when we republish something from a reputable wire service. This was in fact what got the Gleanner into trouble in the first place, where the Associated Press carried an erroneous story that we then published and had to apologize much later and pay that significant sum. There is no liability for republication by a third party in respect to the internet. In other words, if I publish a story online and I subsequently pull it down, but it was captured somewhere else and republished, I am no longer liable. The limitation period for bringing a libel suit against a media house has been reduced from 6 years to now 2 years. And that is consistent with the feeling or the notion that if you are liable and you are aggrieved, you would move quickly to correct such wrongdoing. The same applies for information published on the internet. It is 2 years from the date first published on the internet. The disappointments in these recent changes, however, is that there's no shift in the burden of proof. And the committee was pushing for the New York Times versus Sullivan model, which exists in the United States, where if you libel a public official, it is up to the public official to determine that he is not what you just said he is. Under our system, if you libel a public official or you libel anyone, you have to prove that the person is what they said they are. So the burden of proof is on the media house, which causes a lot of difficulty in terms of doing the thing that we're set out to do, which is to eliminate corruption, but I'll speak to that in a little bit. The jury assessment of liability remains, but the win is that the judge now sets the award, which we felt in very technical cases such as libel, that the judge is best suited to determine what awards. And then the last disappointment is that damages do not have to be pegged to the awards in personal injury matters. If you advance, I think you'll see a message down there. This is what we've been pushing in Jamaica and hope to push across the region. These changes that you see here give media no greater power to root out corruption. What it allows for is a more efficient application of what remains a strict law. And so if you advance to the next slide. I sat in my hotel room preparing for this and I said, let me take a look at what's happening around the region. So this is probably an incomplete list, but what heads the list and what is fact is that Jamaica ranks 13 on a list of over 180 countries in terms of press freedom. However, we rank 83rd or very poorly on the Corruption Perception Index. So how is it that we have such great press freedom, but yet we rank so high in terms of corruption? Something is wrong. And it points back to the message or the conclusion on the earlier slide, which is, does the press have sufficient power to tackle this beast of corruption? Next slide. So, the Jamaican situation, the media houses, the Press Association worked on this revision of the Code of Ethics, but there was a disagreement on whether we needed to establish an independent press council. This is something that the media houses and the Media Association of Jamaica opposes. So unlike in the UK where the hands have been forced for the media houses there to set up their own press councils, we believe that it is in the wrong direction and that self-regulation is the best, self-regulation by the media houses themselves is the best way forward. The recent update of the libel laws, as I said, has resulted in a renewed request for the press council. Previous attempts at press councils failed in the 1970s, and most media houses have enforced codes of ethics which actually go beyond what has been agreed up to the point of refusing to establish press councils. Media houses want to remain independent in enforcing their codes. They want no external influence other than the current laws. We believe that plurality of views is very necessary for a healthy democracy. libel laws provide, the current libel laws in Jamaica provide sufficient remedy for aggrieved persons. As I said, it's very strict. If you take us to court and we've done wrong, the awards of damages are significant. Our current legislation does not provide for binding action of the council being a remedy in the courts. So I could go to the press council, it could be adjudicated that I am wrong, I issue an apology, and the aggrieved takes that same process through the court and uses it against me, and I have achieved nothing. I've just incurred greater cost through the administrative process of running the council. A keen observation or a curious observation is, why is it that the journalists are pushing so hard for the establishment of a press council when they are at the source of the offending publications in the majority of cases? So it is the media houses that need to be punished. Finally, and one of the biggest reasons why we're in opposition to a press council, Jamaica is very, very small, as with many other Caribbean islands across the region, with pockets of influence which overlap in most cases: business, political interests, nefarious interests. And so what is truly independent is a question that we ask. Next slide. So the intended functions of a press council: it is composed of, and I put in quotation mark, independent members. Again, small countries with overlapping interests with significant influence. What does that do to plurality of views? You now have control over what is a few media entities in each of the islands. So they will handle appeals from media workers who feel aggrieved by breaches of code from the employees. That, we believe, is one of the reasons why journalists are pushing so hard. But is that really that big a problem in the region that cannot be dealt with on an individual media house basis? It is also there to handle appeals from members of the public who feel aggrieved by the breaches of the code. They will investigate and adjudicate on breaches of code and force media houses to publish rulings. Media houses will then be bound by the decisions of the press council, and media to participate in funding. Media has the burden to participate in funding such a body. Next slide. So the message of that is, press councils exert external control over editorial decisions of media houses. Media houses don't need that. They need better internal self-regulation. These are the Leveson recommendations that I believe Lord Anthony went through pretty well, so I'm going to skip over it, other than to say that Leveson did say, establish an independent regulatory body, and also to establish an arbitration system whereby the aggrieved can go through and have their issues dealt with without having to go to court, and that one key instrument of getting people to participate is to have larger fines for people who refuse to subscribe. Next slide. The Royal Charter, don't need to go through that. Lord Lester went through that in pretty good detail. So next slide. So the impact of the Royal Charter for the region. Certainly it provides a basis, and this is not just for the Caribbean, this is now for Latin America, as was said earlier. It provides a basis for other governments to seek to impose a similar regime, irrespective of the democratic health of that country, the prevalence of corruption, and the economic climate that exists. UK laws and courts considered world standard and referred to for most countries. So I think it was said earlier that, I think it was the president of Ecuador, that Korea, that said, look, they're following our rule. But they can also use that as justification for what it is that they have done, which is a very dangerous situation. And then finally, this is what IAPA exists for. Government involvement in press affairs is not a good thing. Ladies and gentlemen, thank you very much.
Thank you, Chris, for the brilliant presentation. I have a request from Lord Lester to comment on your presentation.
Thank you very much. Mr. Barnes was far too polite to mention the fact that I was the unsuccessful advocate in the Gleanner case, coming before a hostile judicial committee of the Privy Council led by Lord Hoffman. It was one of the worst defeats of my life. I don't think it was my fee, however, that contributed greatly to the damages borne by his fine newspaper. What I wanted to try to explain, especially for the benefit of those of you who come from common law systems like the United States and the Commonwealth Caribbean in particular, what I want to try to explain is why I do not like the American system, the United States system enough, and why I certainly think that what happened in Jamaica is not good enough. The problem with the United States system, which began with the New York Times and Sullivan, as Mr. Barnes has said, is that whereas it began with a public official, a police officer, Sergeant Sullivan, in the police department of Alabama, suing the New York Times for an advertisement by the NAACP. And whereas in that case, the Supreme Court fashioned a marvelous new rule binding Alabama and all the other states of the Union, the problem is that they quickly extended it to baseball coaches and belly dancers and dolphin trainers and anybody who could be termed a public figure. And instead of concentrating, as they should have done, on the content of publications involving defamation, they concentrated instead on the identity of the publisher, which was a mistake. That is why we in the United Kingdom decided not to change the burden of proof, but to do something much more subtle. And my American media law friends, of whom I have many, say to me they wish the United States were free to do what we have done in the United Kingdom. Of course, the burden of proof does shift in my country if a government body tries to use libel law. I established long ago in a case I argued called Derbyshire that when a government body seeks to use libel law, they can't do so unless they can establish malicious intent or recklessness, rather like the Sullivan. But what we have spent 3 years doing, and I do wish my colleagues in the Jamaican Parliament had followed this, we've had several joint committees of both houses of Parliament. We've had the government thinking and rethinking. We've had me working for a year on my own bill. And this is what we came up with. And I just want you to know this, because although you're not all lawyers, it's important to see a way forward when it comes to civil libel. The first thing we do is to say you can't bring a libel claim at all unless you can prove serious harm. So we create at the very beginning a hurdle which the judge has to respect. The second thing is that instead of shifting the burden of proof in an unfair way onto the claimant, we have widened the defences very broadly. The defence of honest opinion, the defence of qualified privilege, but above all, we have created a new public interest defence. And what the new public interest defence says is that even if you defame someone, even if it's a false and serious defamation, even if you've done so and published, and even if you can't prove the truth of the defamation, nevertheless, if you can show the publication is in the public interest, you have a complete defence. And one of the factors that is taken into account in the new public interest defence is whether you have a press complaint system that works properly. And if the publisher belongs to self-regulation and has high professional standards and has used those standards in news gathering and publication, they have a complete place. We've also abolished the right to trial by jury for the reasons Mr. Barnes has given. There's only now a presumption of no trial. And above all, we have thought about the victim. What about the impecunious victim of a libel and her access to justice? And we have abolished the normal costs rules in order to be able to shift costs from the strong to the weak, to enable both the claimant to bring a claim, if of limited means, or a defendant to defend a claim, if of limited means. And finally, we have encouraged ADR, alternative dispute resolution, in order to try to get cases away from the courts into a better context if we can. And the whole purpose of what we have done is to take away from my profession well-paid fat cat barristers who earn an enormous amount out of libel law. We have taken away from them a good deal of their ill-gotten gains by making libel law something which can be administered in small courts in a much less costly way and with a public interest dominating. Now, as you probably know, in the United States, as apparently in Jamaica, there is no limit to the damages that can be awarded. There is no proportionality principle. But in our system, as a result of the European Court of Human Rights and our own judges, we have limited the amount of damages that can be awarded and also costs in order to comply with the principle of proportionality. So I think that these are all very positive ways forward, and I wasn't invited here in order to talk about the reform of libel law, but to talk about Leveson and the Charter. But in view of Mr. Barnes' very important statement, I thought that you should know that we've done a pretty good job in rebalancing the civil law of libel in the ways that I've tried to summarize. Thank you very much.
Thank you, Douglas. Word is in the floor. La palabra está en la audiencia. Si quiere alguien hacer una pregunta, sí, adelante. Por favor, identificarse antes de hacer la pregunta o el comentario.
My name is David Hume. Lord Lester, I'd like to ask you two questions about prior restraint, which is a principle in the US media. Do you agree with the British government's threat to close down the Guardian newspaper if it continued to publish stories based on the leaks of Edward Snowden? And also, given that you don't like the US media system, would you go as far as favoring a denotice for the US press? Thank you.
First of all, I do like the US system. I grew up in it. I learned everything at Harvard Law School in the early 60s about the US system, and I like the First Amendment. What I don't like is what's happened to it in the last 20 years, especially from a Supreme Court that I like less than I used to, if I can put it in that tactful way. So far as Miranda is concerned, and it's a very complicated issue, I do not think it's fair to say that the government threatened to close down the Guardian. It's fanciful to think they would ever be stupid enough to do that. What they did do was to visit the editor of the Guardian in his offices and to take away, with his consent, the computers and other software on the computer, on Miranda's computer that had been taken at the airport. That whole situation, which has been looked at by the courts, is extremely complicated, and I may talk about it at lunchtime if you still want me to, in the context of surveillance, national security, and so on. Of course, there's no question of the government closing down the Guardian. So far as prior restraint is concerned, we take a slightly different position from yours. As you know, under the American system, you can virtually never get prior restraint. The one exception is in cases like SNAP, where a security agent is disclosing memoirs in breach of contract, or where you're disclosing truth. In our system, in the European system, you can only get a prior restraint in very exceptional circumstances. An example of a very exceptional circumstance would be Pastor Jones burning the Quran with intent, stirring up hatred against Muslims, leading to murder, mayhem across the Indian subcontinent and so on, where in Europe, I don't say only in the United Kingdom, but in Europe, we would regard it as a bad system of justice if that could happen with no prior restraint. On the other hand, an example where prior restraint is completely unconscionable would be, for example, in the Max Mosley case. He was the strange, perverted Englishman who liked to be flogged by prostitutes wearing Nazi uniform, and where his strange behavior was disclosed disgracefully by the news of the world at the time. He argued in Strasbourg that before a newspaper threatens to invade private life, they should tell the person concerned so that he can apply to the court and get an injunction. And I intervened on behalf of the Guardian in that case, and we won. And we said there are only 5 countries in Europe, all former members of the Soviet bloc, where you had to give notice in order that there could be a prior restraint, and the damages were the right remedy. So it's a very long-winded answer to your question, but what I'm saying is prior restraint, very rare, but not the situation in the United States, with respect.
¿Alguna otra pregunta? Yeah, please.
My name is Joseph Guilher Delva. I'm from Port-au-Prince, Haiti, and I'm the head of a journalist organization in Haiti called SOS Journalist, and I'm a long time participant in IPA meetings. I would like to just make a comment rapidly because I think that's one opportunity I have to do it because it's very serious, the case of Jean-Dominique in Haiti. It's the most famous journalist in Haiti who was killed on April 3rd, 2000. April 3rd, 2014. It's been 14 years since an investigation has been going on. And for the first time, we can say that we have unprecedented progress, but this is also the time when the things become even more difficult, more dangerous, because the killers, they feel that they are coming their way, and they are really, really mad. And I can tell you that even myself, sometimes I cannot sleep at home, and now sometimes I have to give me security guards if I'm going to places, because those who killed Jean-Dominique are very powerful, and they are still very powerful. And for example, an investigative judge issued a report recently naming who plotted to kill Jean-Dominique. And they said it was a senator who worked for former President Aristide, and test witnesses said before the judge, and I talked to those people too, who said under oath that former President Aristide ordered the former senator to plot the assassination of Jean-Dominique, but the judge, because he's so afraid, and I talked to him, because I'm also the head of a commission, journalist commission working on cases of journalists killed in Haiti. And the judge said, and he told me, of course I didn't say that publicly because I want to protect him too, he said that he could not put the name of Jean-Bertrand Aristide because he would not be able to walk in Port-au-Prince or to go about his business. He would have to leave the country, then he could not name him. But I had to say what was in the case, and now it's a lot of problems, and the judge the cases before the appeal court. And I won't say much now because I don't have enough time, but I think I will propose at the end of this meeting a proposal, because we would want to have the support of IAPA to move this forward, because it's a very powerful, very serious matter in Haiti. The case of Jean-Dominique, of course, we are working on several other cases of journalists killed in Haiti, and we need organizations like IPA to support the effort. And also another threat is that there is a senator in Haiti who is trying to propose a law, a defamation law, to restrict press freedom. And of course we are fighting that, and we need IPA to support us also. If there is a resolution, when I go back to Haiti, I say IPA is supporting the efforts to block that law, and we don't want that law. Of course this can help. And also there are 2 policemen who are security guards for the president. They beat a journalist, and there's a judge who called them, they refused to appear, and nothing is happening. The judge even issued arrest warrants against them. Nobody is implementing, is enforcing the warrants, and nothing is happening. Of course, in a piece of paper, in a resolution, IPA would call on the president and the authorities to make sure these guys, they appear before the judge. All that will help protect journalists. But of course, I have to say that we cannot say that we don't have press freedom, that in Haiti we cannot say what journalists can say what they want to say. But of course, there are also the risks. But also the problem is, as my colleague from Jamaica said it, it's not only you say you have press freedom that they're not going to arrest you immediately because you give a news, even though you are still at risk because there are groups who would want to attack you. It's access to information. Because they can say, oh, you're free, but they're not giving you any access. But we need to address this problem, access to information, to make sure that to fight against corruption and to have transparency and so on, so that we can achieve all that. So if you have comments on those, I would appreciate it, but that's what I wanted to say now. But I will propose a resolution, particularly on the case of Haiti, to support the struggle we are doing. Thank you.
You can write down your proposal and submit it to the Resolutions Committee. Thank you. I would take just one more question because we are running out of time. There. Well, first there.
Para el señor Lester, mi nombre es Yari Gómez, pertenezco al grupo Extra, el diario de Costa Rica, el diario Extra. Somos un periódico sensacionalista y muchas veces vamos a las cortes por el famoso tema de cómo definir el interés público. El señor Lester en su exponencia habla del interés público. Me gustaría tal vez como que lo amplíe o cómo se basa en otros casos, o sea, cómo podemos defendernos ante las cortes con la definición de interés público. Gracias.
That's an extremely good question. We originally listed factors that we thought were relevant to the public interest. We tried to answer your question in that way, and so we had a whole series of factors. Then we decided that the whole thing is case specific, and that context is everything, and that in the end you have to leave it to the judge to do so. And so I can't easily, I mean, the balance between privacy, reputation, and the public interest is obviously a vexed question everywhere. If you reveal that I am homosexual, for example, when there is no reason for doing so, other than to sell newspapers, then that is not in the public interest. On the other hand, if I am a hypocrite, and I go around condemning homosexuality, and I'm gay myself, that would be an entirely different matter. And so I can't really give you a better answer than to say we have good judges in my country, and we decided it's better to leave it to the judges than to Parliament. I am strongly against a privacy law, defining it by statute, because I can't trust my fellow politicians. And if I have to choose between my fellow politicians, of which I am one, and judges, I choose judges.
I will take just one more question. Go ahead.
Diana Daniels, and I'd like to ask Lord Lester whether there is an application of the self-regulatory system that was created in response to the Leverson report as it applies to bloggers and the new media, because I think that the self-regulatory system that you refer to really is the product of old media, and I'm interested in how it applies to new media.
I so much wish to have the time to do justice to these questions. The problem about the social media, the new media, is of course largely we're dealing with electronic, digitalized material. And in that context, we are grappling with what should be the liability of the internet service provider when it comes to the new, or anybody else, when it comes to the new media. As you know, in the land of the free, you have an absolute immunity for internet service providers. In China, you have the very opposite, and in Russia too. In Europe, we have a typical compromise, which is that when there is a violation of privacy or a reputation, we have a give notice, take down procedure, which operates. But the truth is, I'm glad to say, that at the moment it's impossible to regulate the jungle of the new media. And the new system we're talking about is about the press, yet, as you say, in a rather traditional form, and not the new media. But there will be, for example, satirical magazines like Private Eye, or the ordinary individual citizen critic, who will not be part of the new scheme, and rightly so. I think what I really think is this: journalism should be a profession and not just a business. And it is justifiable, therefore, to say to the press, to say to all of you, if you hold yourselves out as a profession, behave like a profession. And behave like a profession by having your own regulatory system which promotes good standards of journalism, and when there are mistakes made, can give redress to the victims. And that's really what that part is about.
I will thank Lord Lester and Mr. Barnes for this great panel we have had, and I will call for an applause for our guests. Now I'm going to the floor, well, not the floor, the medium. Lo que vamos a hacer ahora es, voy a llamar, ya estoy llamando al vicepresidente por Perú, luego voy a llamar a Ecuador, el informe de Ecuador, luego el informe de Panamá, y luego de eso vamos a tener el panel sobre Venezuela. Así que por favor, Perú.